But now there are some exceptions to this rule. Like in all rules in law, we have some exceptions. To this rule also, we have some exceptions. So these are the exceptions to caveat emptor. Caveat emptor tells us that buyer should be aware, he should be aware. So the exception to this rule will take the responsibility away from buyer and again put it on the shoulders of the seller. So now again the seller will be responsible in the following cases. Now what are these cases? If you run through these cases, you'll find out that these are the same cases that we've done in implied conditions and warranties. I'll just run through these cases. The first is when the buyer relies on seller's judgment. This we have already covered in implied conditions. Quality or fitness of purpose or use. Second, sale as per sample. Again, we have covered this in implied condition. Sale as per description. This has also been covered under implied condition. Sale by sample as well as description. This has also been covered in implied condition. Quality or fitness by usage of trade. This has been covered in implied warranty. Sale of branded products. Now, what do you mean by sale of branded products? When the seller is selling some products which are branded, which sell because of the brand value, which sell because of the brand. In such products, if they do not suffice, then who's responsible? Seller is responsible. You go to the shop and tell him you want a Cadbury chocolate. Now if there's some defect in the chocolate, then you can go to the seller. Okay, even though you bought the chocolate and had it half, then you found out there's some defect in the chocolate, you can go back to the seller and say there's a problem. The seller cannot say I am selling a product which sells by brand, so go to the company who owns the brand. No, the seller is responsible here. And this is the reason why if we have defective cold drinks, defective chocolates, we go to the seller who had sold us and not directly to the company, even though we purchased it by brand. The last is sale by fraud or misrepresentation. If the seller has committed any fraud or misrepresentation, then you cannot make the buyer responsible for it. The seller remains responsible. This is pretty much logical. You cannot say the buyer should be aware when the seller is making fraud. He's making fraud, he is deceiving the buyer. So it is beyond buyer's conception and perception to know that the seller is making a fraud. If he comes to know, well and good. If he does not come to know, the seller remains responsible. So mostly these are those cases which are covered in implied conditions and implied warranties. So in short, let me tell you, all the points of implied condition and implied warranties are exception to the rule of caveat emptor. Okay. So now for your understanding, memorizing and for your easy remembrance, we have made an acronym for these, which is jam sold but bad. J is for judgment, S is for sale as per sample here. The M is for misrepresentation, so let me number them. This is for 1, this is for 7. M is for sale by fraud or misrepresentation. This S is for 2, this D is for 3, this B is for 4, that is both. This T is for trade, that is 5, and this B is for branded, which is 6th. So jam sold but bad.